Hey, welcome to Case Briefs with Megan. Let's make this case brief. So if you live under a rock, you might have recently heard that the Voting Rights Act of 1964 has recently been repealed, but did you know that this is the first time that this particular piece of legislation has come into question? The courts have already tackled this piece of legislation in the case South Carolina versus Katzenbach. This is a big con law case because we're talking about one of the most important amendments when it comes to equal rights, which is the 15th Amendment. The 15th Amendment is what gives everybody the right to vote, no matter what your skin color is, and this was passed after the Civil War ended. Southern states still had a hatred of people of color, so you still had people who were trying to figure out ways to get around the 15th Amendment. Yes, you could vote, but you had to take a literacy test. Yes, you could vote, but you had to pay a poll tax, and maybe you were too poor to pay that poll tax. Yes, you could vote, but there's a scary man at the door telling you that, you don't look like you should be able to vote, and that's kind of scary. This is a major issue to make sure that we have fair elections. So in 1964, Congress passes the Voting Rights Act. Now, what does the Voting Rights Act do, you might ask? One, it bans literacy tests in places where there's a known history of discrimination. The other thing is that it allows for people from the federal government to come and oversee elections to make sure that they are run fair and square. The biggest things that the Voting Rights Act did was that it called on states and towns that had a big history of discrimination to submit for pre-clearance or approval from the federal government before they were allowed to change their voting law. Now, this is where South Carolina has a problem. This is where South Carolina takes it all to court and they're like, look, Congress is way overstepping their constitutional authority. States are supposed to be the people that run the elections, not the federal government. This is them trying to claw their way into our state elections. It's supposed to be separate. This is going way overhand, guys. The issue that we have here with this case is, does Congress overstep their rights underneath the 15th Amendment by enacting the Voting Rights Act? Courts actually say no in this case. Courts say, look, let's read the 15th Amendment again. Look a little bit closer. What does it say in Section 2? Oh, what does it say? It says, this amendment can be enacted under appropriate legislation. What does appropriate legislation mean in this case? That means that when you're a state that has a history of discrimination in your elections, Congress might actually have to pass some pretty extraordinary legislation to remedy the wrong that you have done. In this case, it's the Voting Rights Act. Congress passed the Voting Rights Act, they already had a long list of all of these lawsuits based on discrimination in these cases due to the elections. In this case, the courts essentially say, look, the 15th Amendment doesn't just prohibit racial discrimination in our elections, it also gives Congress a little bit more power to enforce that prohibition on racial discrimination. In other words, it kind of gave Congress a little bit more teeth when it came to making sure that elections were fair. To also say, look, with this long history, it's showing that the states aren't really learning anything. We keep on trying different many ways of trying to remedy this, but it seems like we have to take extraordinary measures for states that just will not listen. I also want you to remember that South Carolina brought up the problem of the states are supposed to be the people that run the elections. It's not supposed to be the federal government. And this is where the courts actually take a different stance on this. In this particular case, say, look, yeah, the states do have the broad authority to regulate their own elections, but there is a limitation according to the Constitution, and that's when you are interfering with the people's constitutional rights to free and fair elections, that's where the federal government can step in and make sure that there's some oversight. In this case, voting rights and making sure everybody has a right to vote outweighs the state's ability to regulate their own elections. Therefore, in that particular case, the Voting Rights Act was not considered unconstitutional. If you learned anything from this case, maybe take a look at some of the legislation that was just repealed.